Okay, going to discuss this particular question. The judiciary has too much influence for an unelected body. Analyse and evaluate this statement. So where's this statement coming from? Well, the classic situation where ministers, as the elected representatives of the people, are arguing that they have perhaps been undermined by the judiciary and have too much influence for a body which is unelected and therefore unrepresentative of the people. So we're going to take you through that. The way I'm going to do it is I'm going to follow this model again. So it's going to have an introduction, it's going to have 3 key points or assertions that we're going to discuss in a balanced way and lead to a conclusion in the end. Reading which is useful around this. Well, there's this article which compares the US and UK Supreme Courts, which certainly looks at the level of power that the UK Supreme Court has in relative terms. This one, the UK Supreme Court, has it changed anything? Looks at particular cases and also whether or not the impact of the Supreme Court is possibly as much as has been suggested. And also that in relation to judicial review in the UK. The amount that judicial review has increased over time, the criticisms that it's brought from ministers, but also the way in which it can be defended. So let's get into it. Judiciary is too much influence. Well, remember that you should always in your introduction define your terms. Simply set up what the Supreme Court is. The fact that it was created in 2005 within the Constitutional Reform Act, opened in 2009, and it's independent of political institutions in the UK. What's interesting, as we know about the Supreme Court, is the rise of the profile of the Supreme Court over that period of time, and especially the amount of activity it's had in terms of the number of cases. This has caused some concerns among ministers. Chris Grayling suggesting that the court was a promotional tool for left-wing campaigners, concerned about the level of influence it has beyond perhaps its representative nature. But remember, the level of influence must be considered in terms of its true level of constitutional power and the impact it can really have on challenging government decisions. And that's what we'll look at now. So our first point. Well, our assertion could be that the court has proved influential in challenging government decisions. And the argument in favour of that really sits around the fact that the government has had some major decisions overturned by the court, where the court has decided the executive acted well beyond their constitutional powers. The court has also shown some way in which it's considered the nature of devolution and the growth of power that has occurred within devolution away from centralised government control at Westminster. The examples of that, well, the 2 big ones are the Article 50 and also the prorogation of Parliament by Johnson, both of which the Supreme Court said that the executive gone far too far beyond parliamentary sovereignty. It led to David Davis MP tweeting that unelected judges are calling the shots and the power should be with the people. Now, that argument to say it's too influential and it undermines the will of the elected government is to ignore the fact that the government still has capacity, when it has a parliamentary majority, to alter the legislation to suit its own growth and powers. So in terms of national security, devolution, all those different areas, there are ways in which the government can actually reassert its control over the nature of its power. It's done this already in terms of anti-terrorism legislation. And remember, of course, that the court can only influence cases when they're actually brought to them. So the government's actions can only be challenged in that sort of situation. This would imply that perhaps ministers may argue that the Supreme Court is stopping the government from getting things done. But the Supreme Court's role and appropriate influence is actually providing a brake on the government's acting illegally and making sure they work through Parliament effectively. The second point, the second assertion, could be said that the court has become a quasi-legislative chamber. In other words, it's mimicking the nature of Parliament as a place where legislation is made. Some have suggested in favour of this argument that the role of judicial review has actually led to an over-interpretation by the judges. They've used the European Convention on Human Rights as a means to actually look at legislation and change the tone of legislation. Ministers would point to the fact that there's been a huge growth in the number of cases that the Supreme Court is looking at. Cameron went as far as to say that judges are using the ECHR to sort of deliver a privacy law without actually Parliament saying so. And the court has certainly shown a willingness to make judgments in incompatibility in a range of different areas, from same-sex marriage through to anti-terrorism laws. However, if you're challenging this, you once again want to look at the actual nature of constitutional power the court has. The court can only ever challenge and interpret laws that Parliament has already passed. It is Parliament that actually gives the Supreme Court the power in which to do its work. And of course, as we know, Parliament represents the people. So in the passing of the Human Rights Act and the Freedom of Information Act, what you find there was Parliament giving the Supreme Court the means by which they can make interpretations on future legislation and whether or not it's compatible with it. Therefore, what can we say? Well, the claim that the court is too influential in the creation of legislation is really to ignore the ongoing power of Parliament to pass and repeal laws that the courts actually judge upon. And perhaps it's more a reflection of people's concerns about the role of the Supreme Court in actually doing their job correctly. The final point is to say that the Supreme Court and being unelected is actually a strength and not a means for criticism, because it allows legitimate influence. As we know, the court is appointed independently of all political institutions, and therefore their lack of accountability to the electorate or other interest groups gives them a level of impartiality which you could argue gives them a legitimacy in the decisions that they make and the power that they use. Lord Woolf, as we said before, was very keen to actually point out that this is the role of the Supreme Court. It has to remain vigilant to ensure the executive acts in a lawful fashion. However, it's perhaps the most significant argument as a concern of where the Supreme Court is at, is looking in terms of its composition. There are concerns obviously with the nature of the court being white, old and male, and not necessarily representing the nature of the country as a whole. So it's an easy criticism that could be levelled towards the Supreme Court by saying it's out of touch with the demands of modern society, and perhaps shouldn't be ruling in the way it's ruling because of the nature of the court that's there. When you're looking at the court on how it actually looks rather than how the level of experience that it enjoys. You could also talk about the fact that judges have been criticised by politicians for being too liberal in the areas of immigration and deportation. Again, this is to ignore the fact that the court's role is to protect minority groups within society, not necessarily reflect the majority opinion that is being said in any particular election. Therefore, what's the overall view? The claim of the unelected power is a simple criticism for those who are against the decisions made by the Supreme Court, but clearly ignores the important role that an impartial institution provides in the protection of citizens' rights. So when we talk about an unelected body having too much influence, what we're talking about is the strength of the unelected body in actually providing a means of protection against the tyranny of the majority. So we get to our conclusions. The judiciary has too much influence for an unelected body. So what's your judgment? Does the court have too much influence? What does the evidence suggest on this? Remember, you should have three parts to your conclusion. Your first is your judgment, and then what you should do is you should accept some of the counterpoints. So if you're arguing that in fact the court has too much influence, then acknowledge some safeguards that do exist. Does the constitutional position of the court mean that there are limitations to its power? The fact that Parliament is the one that really defines the power of the Supreme Court. If you believe the influence is appropriate, what are the ongoing concerns? Has the court actually caused problems for elected governments with a mandate from the public to keep society safe? But in the end, you want to be able to therefore, in your third part of the conclusion, reinforce your judgment. So if you're in favour and saying that the court has too much influence, you're focusing on the importance of an elected government as the expression of the will of the people against an unelected and unrepresentative court. If you're against this and you're saying that the power is appropriate, you're probably saying that there's an importance to balance executive power in the UK to protect rights and constitutional principles. But that decision is yours. Good luck.